Judge Fowl continues, if that conclusion is wrong for any reason, the Tribunal also has the power under Rule 47 to dismiss a claim if a party fails to attend or to be represented at a hearing. The only caveat is that before doing so, it must consider any information which is available to it after any inquiries that may be practicable about the reasons for the party's absence. The reason for her absence is clearly her reluctance to answer to the warrant. Once again, it is no part of the Tribunal's function to assist claimants in evading the police, and so that is not a good reason for her absence. It is also the second occasion on which she has failed to attend, and so if there is any question about the appropriateness of a strikeout order, the claim is dismissed on that alternative basis. Mischaracterization of non-attendance. The Tribunal states that my absence was clearly her reluctance to answer to the warrant. This misrepresents the facts. My absence was due to safety concerns arising from retaliatory arrests, police misconduct, and sustained intimidation by the respondent and its associates. I did not evade lawful instructions in a criminal context. Rather, I sought to protect myself while exercising my right to pursue legitimate civil claims. Fail to consider legitimate explanations. Under Rule 47.2 of the Employment Tribunal Rules of Procedure 2013, before dismissing a claim for non-attendance, the Tribunal must consider any information available and make practicable inquiries into the reasons for absence. In this case, I provided multiple emails to the Tribunal explaining my legitimate reasons for non-attendance. I formally requested remote participation multiple times, in line with standard practice for claimants who could not safely attend in person. Despite repeated requests, I was never provided any details or access for remote participation. Meanwhile, the respondent attended remotely without issue, demonstrating inconsistent application of procedural fairness. Bias and procedural unfairness. By framing my absence as reluctance to answer to the warrant, the Tribunal implicitly conflates civil proceedings with unrelated criminal matters, minimising my claims of bullying, constructive dismissal, and sex discrimination. This risks prejudicing the Tribunal against the claimant, contrary to Rule 3 of the Employment Tribunal Rules of Procedure 2013, which requires tribunals to act fairly and impartially, and to ensure the overriding objective of dealing with cases justly. Alternative measures ignored. The Tribunal asserts that, because this was a second non-attendance, dismissal is justified. However, proportional alternatives were available but not considered, including granting remote participation, which I had repeatedly requested, allowing adjournment, or implementing protective measures for both parties. Conclusion. The Tribunal's reasoning in sections 27 to 28 demonstrates procedural irregularity, bias, and failure to exercise discretion fairly. The stated reason for my absence ignores the documented threats, harassment, and unlawful actions by the respondent, and misapplies Rule 47.2 by failing to genuinely consider my explanations. Denying me participation while accommodating the respondent further evidences partiality and unequal treatment. Consequently, dismissal on this basis is procedurally unsafe and constitutes strong grounds for appeal.